Hello, everyone, and thank you for joining us for today's webinar, Your Family Comes First, a Responsible Adult's Guide to Estate Planning and Asset Protection. We are excited to have two of the nation's leading attorneys with us today. Michelle Lerman is an estate planning attorney in Northern California. She is a certified specialist in estate planning, trust, and probate law by the California State Bar, and she recently released her third book, Create Your Best Legacy. Jacob Stein is an asset protection attorney in Southern California. He specializes in private wealth planning, complex U.S. and international tax planning, and structuring international business transactions. Jacob is a frequent lecturer. He teaches over 50 seminars a year. If you have any questions during the presentation, please use the Zoom chat feature or email them to us. You can use my email address, acamp@aliantlaw.com. You can also shoot me an email if you would like a copy of the CLE certificate, or if you would like a copy of Jacob's or Michelle's PowerPoint presentation. We will be answering your questions at the end of this webinar. And without further ado, I am going to let Michelle Lerman get to it. Thanks again.
Hi, everyone. Thank you for attending today's webinar. And my part of the talk is estate planning opportunities under the Temporary Tax Act. I have a lot to share. This is going to be a jam-packed 25 minutes filled with information so that you can really become the master of your own legacy. There's a lot that I'm going to mention that we're not going to delve into details. I want you to make a note because you're going to have an opportunity for a complimentary consultation if you sign up for that today. And so I want you to make a note of the things that interest you most so that we can be sure to really delve into the detail when we meet. Let's step back for a minute. Let's forget all the legal jargon. Let's forget the word tax because sometimes that can be daunting. And let's just remember for a minute why we're here. This is my dear, dear, dear friend and soulmate, Carrie. Carrie and I raised our kids together. She turned 60 and died 2 months later. Her dying, I deal with this all the time as an estate planning attorney. I've been doing this nearly 30 years. And I deal with death, and yet losing a friend just completely rocked me to the core. It also brought home the importance of what I do for a living, that how critical it is to prepare, because sooner or later we are all going to die. And when we get our planning together and we do it when we're young and healthy, that's really what we want to do, because going through this whole ordeal with Carrie was really the worst thing I've ever had to deal with in my life. And I miss my Carrie. I dedicated the third edition of my book, Create Your Best Legacy, to Carrie. And I want us all to think of her today. With you, you can help me etch her memory forever. Her life and her legacy, just there's so much to learn from that. You'll learn more about that, by the way. My whole foreword in my book, I talk about her and her life. Let's delve into today's topic. We're going to cover the Temporary Tax Act. You're going to learn everything that you need to know so that you can take advantage of the opportunities and you can avoid the pitfalls. We're really going to focus most on the 3 action items I want all of us to take today. 3 critical action items. And just a hint, don't think about leaving this webinar early, because the 3rd action item is actually the most critical and really the most commonly forgotten, very, very surprisingly. So let's see. First, just a little bit about me, why I am here, and why you should listen to me. First of all, estate planning lawyers can be certified specialists by the State Bar. We are certified specialists in estate planning, trust, and probate law. This means that we have passed a full-day exam. There's a lot of vetting that goes on. There's references that are checked. The references they present, they give the State Bar other references to check. We have more continuing education. And face it, if you are doing this critical plan, you want to make sure that you're dealing with a specialist. We also care. My team cares. They're amazing. You'll be able to meet them, Dylan Recht and Sarah Kern, when you come for your complimentary consultation. our goal is really for you to be able to create your best legacy, that the whole planning process should be families engaged in a really thoughtful process. Never, ever, ever plan in secret. If you're planning in secret, then it's just going to blow up. And that's what really estate planning is about. We want to make sure things don't blow up. We don't want you ending up in court and with family fighting. We want you to make sure that you have the right estate plan, and any financial advisor will tell you the right estate plan is so basic, it's so important, and that's what we're going to cover today. So, the Current Tax Act. Key points. First of all, and this one is actually, it's great. There's a great opportunity here. The fact that you can leave $11.4 million free of transfer tax. That means that you can leave that during your lifetime, or you can leave that when you die. You could leave part of it during your lifetime and the rest of it when you die. But this is a huge change from prior law. And if you're married, you can double that exemption. That means that after one spouse dies, you simply file an estate tax return, make an election, and it gets doubled, so that as a couple, you could potentially leave $22.8 million free of estate tax. The annual exclusion gift, that just means the amount that you can leave in addition to your lifetime exemptions above. That annual exclusion, you can give this annually to as many people as you want. It's $15,000. You can, and if you're married, you can give it, your wife can give it. So that as a married couple amounts to $30,000 in annual gifts. This is huge, especially for families with an estate tax issue, because in addition to the lifetime exemption, you can give to your children, you can give to your in-laws, you can give to your grandchildren, and every single year you can get an awful lot of money out of the estate. Also critical under this Current Tax Act is this limitation on the deductibility of state and local tax. For Californians, this is a big deal. This means that property taxes, for example, are limited. You can't deduct more than $10,000 of your state and local tax. So this means that income tax, when income tax deductions are restricted like this, it means that income tax becomes a huge, huge issue. Here's the crux of today's talk. This is a temporary law. That means that the opportunities that are presented, they have to be taken advantage of now, that the law ends at the end of 2025. And then what happens? The exemption amount, the amount you can leave free of estate tax, it goes to half of what it currently is. What it means is that each individual can have a base amount that you can leave free of estate tax of $5 million, then it's indexed for inflation. So the pre-indexed amount is half of what it is now. So really the bottom line of this temporary act is you can transfer a lot more without estate tax, but what you really need to know is that probate avoidance, protection of the assets, say from creditors, from a divorcing spouse, the property tax planning, making sure that everything stays private, those still are critical issues that have to be addressed with an estate plan. This is what happens if you don't have an estate plan. What happens is that you go to court, it's probate. That means a court procedure, a filing fee, and it's very, very expensive. And the filing fees, the fee that goes to the attorney that files everything into probate, everything is based on a statute. It's the gross value of the estate that it's based off of. And as you can see, don't spend $19,000 to $73,000 or more going through probate. It's so much better to make sure that you have your planning done. Sooner or later, the documents are going to be needed. This list is an example of a complete estate plan. So I'm just going to give you a minute to make a note of that. The trust is really the centerpiece of an estate plan, and that's just an instruction manual on what you want to happen if you die and what you want to happen if you're incapacitated. But the key is that all living trusts are not alike. In fact, living trusts are very different. In fact, living trusts can have income tax consequences that are unintended. And so let's dive into that. Reviewing your living trust is a must. It's the number one action item. And the issue that I want you to be looking at, or this might be that you don't have a plan at all. The first issue you're going to deal with is whether you want your living trust to split into two shares at the first death. So in other words, do you want the assets to split into two trusts, meaning a bypass trust and a survivor's trust, when one spouse dies? This type of trust can be a huge tax trap. And the reason is that, let's just say that there were a married couple and one spouse died. Let's just say that the married couple, let's just say Tom is surviving, his wife died. When his wife died, assets were put into a bypass trust. Let's just say it's $1 million of assets. Let's say the living trust had $2 million. What the problem is that when Tom dies, say maybe 10 years later, if that $1 million in value of assets becomes $5 million, when the kids go to sell those assets, the $5 million of assets, they're going to pay capital gains tax, because when Tom's wife died, the value was only $1 million. Now they're $5 million. That means that when they're sold, there's a $4 million gain, and the kids are going to pay income tax on that. And yet when you look at it, if the estate could have passed free of estate tax, why did we need to have a trust that bypasses estate tax? And this plan used to be prepared all the time. Anyone who was married would have this kind of a plan, because you wanted it to, anything that the surviving spouse left in the bypass trust, you wanted it to bypass estate tax. But now you don't need that to bypass estate tax. The law does it for you, and yet it's a huge tax trap because of the way it's taxed for income tax. In order to avoid this, the better type of plan, and what we now draft, is called a Q-tippable AB trust. And it simply means that we draft the spouse's trust as a different kind of a trust with a different kind of tax result, but it still has the same protection. Tom, let's just say, comes into my office and he says, Michelle, I want to change my plan. I'm remarried and I want to leave everything to my new spouse. Do you think he can do that? So with this type of trust, or with a bypass trust, he can't change that protection trust. He can't change the protection trust to leave it to a new spouse. He's going to that because that's set. It's called an irrevocable trust, and so he can't change it. So that's the whole point of this, and that still might be a really important goal, but you don't need to do it as a traditional bypass trust. You need to update it, or if you're preparing a new trust, you need to have it done so that it has the right provisions in it, and we call it a Q-tip AB trust. Another option could simply be an all-to-spouse plan. Leave everything to the spouse. It's simpler. Everything goes to the spouse. The spouse can decide what to do with it. Now, some of you might see this question mark and go, whoa, what do you mean the spouse can decide what to do with it? That might not be what everyone wants, because some people want to know, for example, Tom's wife may have wanted to know, Tom, you can't get remarried and leave that to someone else. That's going to go to our children. Whereas if you had an all-to-spouse plan, when he came into my office, he'd be able to change it. But there are a lot of considerations, not just the protection. And when you come into my office, we're going to talk more about the different types of trusts and the pros and cons, so we can figure out what's best for you. The bottom line is, with an all-to-spouse plan, you don't have any protection, and with the Q-tip trust, you do have protection. But there's different couples have different goals. So what if you aren't married? Well, if you aren't married, ongoing trusts are still going to be a critical part of your plan that we're going to talk about. It may not be an ongoing trust for a spouse. It may be an ongoing trust for a significant other that you're not married to. It might be an ongoing trust for children, and that's still really, really critical, and we're going to talk about how to draft it. They're usually drafted wrong so that you really provide optimal protection. I can't tell you how often I see trusts where the assets go to the children at age 30 or 35. That could be right when the child's divorcing. I mean, I don't want to be pessimistic, but it's just not the right way to do it. It should go to the child and then stay in trust for the lifetime of the child, but let the child have the power to appoint the trustee. Let the child have use of the assets. So there's lots of really important, good planning opportunities. Action item number 2 that I want you to consider is, if you know, even after 2025, that you're going to have a taxable estate, think about getting assets out of your estate. Think about gifting them. Think about selling them. You can do that by creating an irrevocable trust. You get lots of tax advantages. If you know you're going to have a taxable estate and you're not looking at this, you are just making a huge mistake right now, because you could discount the value of the assets going into the trust, and there's just so many planning opportunities. The disadvantage of gifting assets now is that you lose something called the step up in income tax basis when you die. Remember I mentioned in the bypass trust what the death tax, what the trap was, the tax trap? The tax trap was that in the bypass trust, we had said if $1 million went in when Tom's wife died, but when Tom dies, the assets are worth $4 million, we said the kids were going to pay capital gains tax on the gain when those assets were sold after Tom dies. And that's because the bypass trust doesn't get what's known as a step up in income tax basis at death. And so the problem with going ahead and gifting assets now is you don't want to necessarily gift low income tax basis assets, because you're giving up a huge opportunity. You won't get the income tax basis step up when the person dies. If you're married, sometimes what we do is after one spouse dies, that's when we start doing the planning, because when one spouse dies, typically assets get a step up in income tax basis, and then we can gift the high basis assets or sell them into an irrevocable trust. So we're going to get to the third action item, and then I'm going to tell you what you really need to do next, okay? Third action item. Third action item is critical planning, because a retirement account like an IRA or a 401k, they're not governed by a will or a trust. And very often people forget to update the document that's going to control an IRA or 401k, and that document is a beneficiary designation. Also, what happens with a retirement account is that there isn't proper planning, because when one spouse dies, for example, or even if you're not married, when you die, whoever you name, they can name then anyone they want as the beneficiary of the retirement account. So whether it's the surviving spouse that has full control, or it's your children that have full control, you don't know what they are ultimately going to do with it. And then also, when you leave a retirement account, there's exposure to creditors when you leave it and you just name an individual instead of having proper planning for a retirement account. The surviving spouse having full control, if this interests you, or if this topic interests you and it's of concern to you, just write down aggregate property agreement, because we can create an aggregate property agreement that can help make the situation better, that the surviving spouse has full control to change the retirement account. But what we could do is create an agreement called an aggregate property agreement that can pack more of the trust assets into the irrevocable side of the trust. So it's called an aggregate property agreement. The other thing we can do is we can take IRA assets and we can create a specially designed IRA beneficiary trust. This is not your living trust. Do not name your living trust as the beneficiary of your retirement account, but we can create a trust within your living trust to hold the IRA assets, or we can create a separate irrevocable trust to hold the retirement account. The benefit of doing that is that we can design it so you still get this great thing known as a stretch out, That simply means that the beneficiary can stretch out the payments over the lifetime of the beneficiary, the distributions from the retirement accounts. And that means that income taxes are deferred, right? Because you don't have to pay income tax until you take the money out of an IRA, as long as you have a beneficiary designation form. And so we can design the trust so that you can still have the stretch out and you get the creditor protection. But please, please, please do not put down your estate or your living trust. Don't use those words on the beneficiary designation form. Make sure that you plan it properly. The other thing you're going to want to consider with retirement account is what I refer to as the charitable solution. The problem it solves is the fact that the IRA or the 401k, unless it's a Roth, it's subject to income tax after the participant dies. When the money comes out of the IRA or the 401k, it's subject to income tax if you name an individual. The charitable solution is naming a charity on the beneficiary designation form to receive the retirement account. Instead of naming the charity in the trust, name the charity on the beneficiary designation form, because the charity won't pay income tax, but an individual will. And then in the trust should simply provide that if the charity hasn't been taken care of from the retirement account, maybe you've lived a very long life and the retirement account was completely depleted, then and only then does the gift to the charity come out of the living trust. We can also create charitable remainder trusts to hold a retirement account, which can be a great thing to do so that individuals can benefit from the retirement account, and then it can ultimately go to a charity at the end. So this would be a good planning opportunity for someone who wants to protect their family members, other beneficiaries, and also wants to leave assets to charity, and leaving it through a retirement account is very tax efficient. So we've gone through a lot today, but what we've highlighted for you are the most important parts of this temporary tax act. A huge gifting opportunity if you know that you're going to have a taxable estate, and a huge pitfall to avoid if you don't have a taxable estate and yet you're a married couple and you still want the protection of an irrevocable trust. And I hope that the three action items have been clear and simple. And now the next step is for you to go out and create your best legacy. So that I can encourage you to do that, we normally charge for our consultation appointments, but if you call or email today for your complimentary consultation, then you can get started on your plan and you can not pay the fee that we normally charge. We'll sit with you. If you already have a trust, we will be happy to look at your trust. We can do them by Skype or video conference. Coming into the office is fine too. We have several different offices, Northern California and Southern California. And I'm really looking forward to meeting you and helping you create your best legacy. As I say, you want to be the master of your legacy, and sooner or later documents are going to be needed. So let's plan it out the right way. I guarantee it'll be better than anything a court or a judge is going to plan for you. And that's what happens if you don't have a plan. So thank you. Thank you for the opportunity to be here, and we will be answering your questions shortly, and I'll look forward to meeting you for your complimentary consultation. Thanks.
Hello, everyone. This is Jacob Stein, and I think we need to first thank Michelle Lerman for the wonderful job she did on presenting to us on estate planning. Thank you, Michelle. My own presentation is on a very related but slightly different topic. So let me tell you first about my own practice and how it is relevant to this presentation. I am an attorney in Los Angeles. I practice with an international law firm called Aliant, and my practice focuses on complex private wealth work. So what is complex private wealth work? So I get involved in sort of the higher stakes, more sophisticated, more cutting edge estate planning, estate tax planning, international tax planning transactions, and I'm probably best known nationally for my asset protection practice. And I see all of those areas, all of those practice areas, as part of an integrated estate plan, right? So what Michelle has described is the estate planning that applies to the vast majority of our clients. Sort of the fundamentals, the very, very important fundamentals of estate planning and estate tax planning. I would like to build on that and talk about what I refer to as integrated estate planning, which is adding in the more cutting edge techniques. And today the focus of that add-in cutting edge technique will be on asset protection planning. What is asset protection planning, and why are we integrating asset protection planning into an estate plan? I started practicing asset protection planning about 20 years ago, and when I started in this practice area, no one knew what asset protection planning was. And our greatest challenge was simply educating clients and other lawyers about asset protection planning and what is possible, what is not possible. And today we're still, spending a lot of time educating the world at large what asset protection planning is all about and when is it suitable and who is it suitable for. So asset protection planning is an area of the law that deals with shielding assets from claims of creditors. So this would be any third-party creditor. This would include a government agency. This would include a private plaintiff, like let's say in a tort claim. This would be a lender suing to collect on a debt or on a personal guarantee. And anything and everything else you can think of, right? So any sort of circumstances where our clients are facing the risk of losing their assets. And asset protection deals with figuring out what are the structures that we need to set up, and how do we transfer the assets into those structures to minimize the creditor's ability of being able to reach those assets. And sometimes our goal is to make it, let's say, impossible for the creditor to reach our client's assets. And sometimes our goal is to make it very difficult and very expensive for a creditor to reach our client's assets. And I would say that the vast majority of the time, we are looking to make it difficult and expensive to go after our client's assets, and not impossible, because impossible, frankly, often is just not in the cards. Excuse me. So what can we do to make it difficult and to make it expensive for a creditor to go after our client's assets? There are lots of different structures, and a lot of them, I think, very nicely dovetail into your traditional estate planning, which is why I am bringing it up in this conversation and sort of integrating asset protection planning into this presentation. We have found in our practice and 20 years of doing this, probably over 2,000, maybe 3,000 transactions, that our clients rarely think about asset protection planning until something bad happens, right? We all sort of live in this world where we believe that bad things happen to other people, and we do not need to plan for something like that happening because it happens to other people. It never happens to us. So most of our, specifically asset protection clients, come to us after something bad has happened, and they're looking for a way to keep their assets, or as much of their assets as they can. We would like to get ahead of that. We would like our clients to protect their assets before something bad happens. We would like them to protect assets when they're engaging in their traditional estate planning, because that is when it is most effective. The estate planning, the asset protection planning that we can do in advance of something bad happening, even something that is really, simple and inexpensive, will be infinitely more effective than most everything we do last minute. And while our own practice, my own practice, focuses primarily on fairly large estates or very sort of high stakes asset protection cases, meaning where there is a lot of money at stake or a highly aggressive litigious plaintiff, the logic of the practice doesn't change depending on the size of the estate and depending on who the creditor is and how aggressive they are, right? The logic is always the same. If we can take the assets that we own and create a structure where we can argue that we no longer own these assets, that they are now owned by someone else, we have a very good asset protection structure that likely will work if there is some sort of a lawsuit or a collection event aimed at our client. So what are these structures that we would often use, and how do they work together with traditional estate planning? Well, let's take a look at the structures that are commonly used in traditional estate planning. And again, this may vary from a fairly small, modest estate to a very large estate, right? So from a few $100,000 to maybe hundreds of millions of dollars or more, depending on the clients that you represent. So in traditional estate planning, we will certainly have something like a living trust. Does a living trust protect assets? Does it offer any sort of insulation from creditor claims? And turns out that, substantively speaking, there is no protection from creditor claims with the living trust. The law of every state has a statute that provides that assets titled in a trust that is revocable can be reached by the creditors of the settlor, right? So if you transfer your assets into a trust and you have retained the right to transfer the assets back to yourself, creditors are allowed to go directly after the assets of that type of trust. It's that simple and that straightforward. So you will find that every asset protection trust is irrevocable. But before we get into these irrevocable asset protection trusts, a quick note on living trusts, on trusts that are revocable. Is there any use out of them in the asset protection world? And the answer is yes, there is some limited use. We do sometimes use revocable trusts as a means of obfuscating title to the assets, right? So instead of our client owning the asset directly, we may want to change title of the assets and camouflage who owns the assets. So what we will do is we will set up a simple living trust that is revocable by our client, and we will give this trust a generic name, like the Cloudy Sky Trust, which is what I'm seeing at my window right now. And this Cloudy Sky Trust will take title to the client's assets. And these assets may be real estate, they may be interest in closely held entities, bank accounts, intellectual property, or whatever it is that our client wants us to sort of hide for him in a sense, or obtain more privacy for. Not really hide, but maybe perhaps more privacy. And then instead of our client acting as the trustee of that trust, we will appoint someone else, like a third party, perhaps the client's accountant or a close friend, maybe a professional fiduciary, as the trustee of the trust, because this way our client's name will not appear on the title to that bank account, it will not appear on the title to the real estate and so forth. And we're now distancing visually our client from those assets. So if tomorrow there is a lawsuit, or even more importantly, a possible lawsuit, it will often give that plaintiff or the creditor pause before they proceed with their action, because now they're not certain. Does our client own that asset? What kind of a trust is this? Is this the kind of a trust they can breach or not, right? Because from the name of the trust, you should not be able to tell whether the trust is revocable or irrevocable. And I will tell you, as a matter of fact, sometimes we will have clients who will have it set up for them, just your standard revocable living trust, but then use the word irrevocable in the trust name. So then when they take title of their home in that trust, it will say that this is such and such a revocable trust. And that will prevent some plaintiffs and creditors with proceeding litigation. I have seen that personally in practice. It does work. It's not something we will rely upon. It's not something you can rely upon with 100% certainty, But if the client is not willing to do anything other than set up a living trust, you can give them that extra peace of mind and maybe a little extra protection by giving the trust a generic name, and maybe even using the word irrevocable in the title of the trust. But if you want substantive protection, you want a trust that is irrevocable. And the word irrevocable is concerning for a lot of people. It is concerning for a lot of our clients, and it is concerning for a lot of practitioners, because irrevocable trusts have always been perceived as something that is cast in stone, that cannot be changed, right? They're inflexible. We have to commit to that action. Once we transferred assets into the irrevocable trust, we're stuck with that, right? We do not retain the ability to change our mind. That was true for about 400 years or so, maybe more. For as long as irrevocable trusts existed in the English common law. Today, that is not true, not anymore. Today, we are able to structure and draft an irrevocable trust that is not truly so. Not truly so what? Not so truly irrevocable. So we are able now to draft an irrevocable trust where if our client is sued, if there is a collection action, there is a plaintiff, there is a creditor, there is a government agency, we can say this trust is irrevocable and our client has retained no rights over this trust, no control over this trust, and he no longer owns the assets that are sitting inside of that trust. But at the same time, in a more indirect, more practical way, our client will retain the ability to reach the assets of the trust and transfer them back to his name. He will retain the ability to engage in certain transactions with those assets. He will be able to change the trustee of the trust, the beneficiaries of the trust, the language of the trust. And all of a sudden, this traditional irrevocable trust becomes something that is very flexible, that is no longer cast in stone, and clients feel much better about transferring assets to trust like that. And more so for those clients who do not have giant taxable estates, where they do not want to have any sort of tax consequences on transferring assets to a trust, they don't have to, because an irrevocable trust can be drafted in such a way so that it is ignored for all tax purposes, treated like, let's say, a single member LLC, is disregarded for tax purposes. And I'm referring both to the income tax and the gift and estate tax, right? We can have an irrevocable trust that is what's called defective for all purposes. So how do we do the first part? How do we retain control? So first of all, you have to be mindful of the fact that for a trust to be deemed irrevocable, the person transferring the assets to the trust, the settlor of the trust, cannot have the power to get his assets back. Like, he cannot hold that power in a direct fashion, which is not the same as saying that this power cannot exist, right? The settlor cannot hold the power to get his assets back, but the power to get to the assets back to the settlor, it can exist, just not in the hands of the settlor. So if you look at a traditionally drafted irrevocable trust, the ones that have been in use for hundreds of years, you will see that trusts like that usually have a blanket prohibition on the world's ability to revoke them, to transfer assets back to the settlor. And that is not necessary, right? We've kind of more recently, the legal community has realized that for a trust to be deemed irrevocable, as to our client, only our client, who's the settlor of the trust, must give up the right to revoke the trust. We can preserve that right, that ability, with someone else. So nowadays, when we draft an irrevocable trust, we will say that our client cannot revoke the trust, but then we're preserving the power with someone else. And that someone else who is now holding on to the power, we will commonly refer to this person as the trust protector. The trust protector, which is just a term someone came up with and it sort of spread into wide usage, is an additional office we have created within the trust instrument in the trust relationship in addition to the trustee. And this is an office that is exercised in a non-fiduciary capacity, which allows the protector to do a lot of different things, sort of frees them up and releases them from a lot of liability exposure that they otherwise may have to the beneficiaries and to the settlor. So the protector, in addition to being given the power to revoke the trust, therefore returning the assets to the settlor, can also be given the power to terminate the trust, right, to accelerate the termination of the trust and the distribution of trust assets to the beneficiaries. The protector may be given the power to amend the trust, maybe even in a wholesale fashion. The protector may be given the power to change the trustee of the trust, perhaps the beneficiaries of the trust, maybe change between grantor and non-grantor status, change the governing law of the trust, and so on and so forth. And we can give the trust protector all of these powers, some of these powers, whatever is suitable for that particular transaction that we are working on. And clients love this concept of the trust protector because it does allow them, it allows them, not directly, but it still allows them to retain control over their assets. And for all of our clients, retaining control is a big, big deal, right? This is what gives them peace of mind. So, I've been using this concept, I would say, for the past 10 years approximately. And since I started using it about 10 years ago, I don't believe I've drafted any irrevocable trusts, well, maybe there have been one or two, that did not utilize a trust protector. It is a great concept. All of our clients, when they are setting up inter vivos irrevocable trusts, would like to retain control. Right? If you were to think of your own circumstances, if you were to transfer assets to an irrevocable trust, wouldn't you like to do it in a way where there are no tax consequences and you can retain control? Of course you would, right? Because it does not create any headaches for you. If tomorrow circumstances change again, or you simply change your mind, you can unwind everything. And there is no cost to pay to do so in any fashion. So when we are looking to engage in some integrated estate planning for our client, meaning we want to incorporate asset protection planning into their overall estate plan, we do discuss with them and we do consider setting up a living trust that is irrevocable, right? So it's technically irrevocable, but practically clients may retain all sorts of control over a trust like that through this trust protector, who is usually, a friend or a family member, and so forth. And I do discuss the concept of the protector in a lot more detail in your handout materials. So if you're welcome to read up more on that. I don't want to spend any more time on protectors. And as with anything else that was presented in this presentation, either by myself or Michelle, if you do have additional questions, comments, concerns, please feel free to reach out to us, shoot us an email. We always respond. We will be happy to communicate with you. You're also welcome to just pick up the phone and call us. And we're always happy to speak to those who have taken our courses. Okay, moving on. So we're creating an integrated estate plan. And I believe that if you are setting up a living trust, why not add an element of asset protection to it? You're avoiding probate, you're providing for what happens in incapacity, you're providing how the assets will go to the kids. Perhaps there's some nominal estate tax planning taking place through the living trust, like with an A-B split. Why not add a layer of protection by making this living trust an irrevocable living trust? We do this now on a fairly frequent basis, and I tell you it works well. And if you are an estate planner, consider it. It may set you apart from many of your other colleagues who continue to practice estate planning sort of with blinders on, just continuing to do the same thing day after day. For some clients, that's perfect. They do not need anything more than just a traditional estate plan. And perhaps some of your clients will benefit from more expansive thinking and integrating asset protection into the plan. In addition to creating irrevocable living trust, we can also consider using other types of irrevocable trusts that either are used otherwise in estate planning or are not. So trusts that are frequently used in estate planning that we often will consider for our clients will be irrevocable life insurance trusts, intentional defective grantor trusts. Those are probably the two most commonly used ones because those are irrevocable trusts, and being irrevocable trust, there is asset protection involved, right? And just kind of a quick note, if you want to have a good asset protection trust, there are only like 3 elements that we need to satisfy. We need to make sure that the trust is irrevocable. We need to make sure that there is a spendthrift clause in the trust, which I think is pretty much automatic nowadays in every trust. And we want to give the trustee of the trust as much discretion as possible when it comes to making distributions. So, if you are looking for an asset protection trust, that's really what you need to focus on. Those 3 primary topics, right? It needs to be irrevocable, have a spendthrift clause, and have discretionary distribution powers. And then in most jurisdictions, in about 2/3 of the states in the US, we want to make sure there is a third-party beneficiary in the trust, that the trust is not self-settled, meaning that our client is not setting up the trust for his own benefit. That now works in some states, but it only works in those states. And if you have clients who live outside of Nevada, Delaware, Alaska, and other what are called domestic asset protection jurisdictions, you would want to set up a trust for the benefit of a third party, like a family member or children and the like. So I've noticed that people often get distracted by terminology. They will see these trusts being advertised on the internet, like the Fortress Trust or the Bridge Trust or Land Trust, mostly marketing concepts. Land trusts, this is a concept that exists in the Midwest. Land trusts are not asset protection trusts. They are just intended as a means of camouflaging title to real estate. It's sort of like a revocable living trust with a generic name. So you can replicate it anywhere you want to, but there's no substantive protection because land trusts are revocable. And then, the so-called bridge trust, fortress trust, they can be great asset protection trusts so long as they meet the requirements I stated, right? Irrevocable, spendthrift, discretionary, and in most states, third-party beneficiary. So how someone calls their trust, and often it's just a marketing term, is not important. Look for the substance of the trust, look for these elements to determine whether it is a good asset protection trust. So for example, if you look at the intentionally defective grantor trust, which is one of the most frequently used estate tax planning trusts, right? Once you start getting into somewhat larger estates and you're starting to think about estate tax planning for your clients, you will start seeing IDGITs a lot. And IDGIT is usually a great asset protection trust. It is irrevocable. Like every trust, it will incorporate the spendthrift provision. We can certainly make trustee powers discretionary, or at least trustee powers relating to distributions. And then always the third party will be the beneficiary. And IDGIT is always for the benefit of the kids, not for the benefit of the settlor. And recall that by incorporating the concept of the protector, our client can retain indirectly through the protector, through this trusted person, a lot of powers over the trust. So that's just kind of a few words on more traditional estate planning trusts. So if you're already engaging in estate planning for your client or estate tax planning, consider how can you take those structures that you're setting up anyway and give the client the additional benefit of asset protection. And I will tell you, there have been so many times, probably a couple hundred times over the past few years, when clients came to me and said, listen, I understand that trusts are used to protect assets and something bad just happened, but fortunately, all of my assets are in the trust. And I asked them, well, what kind of a trust do you have? And they will say, well, we have a living trust. And I'm like, I bet you your living trust is revocable and that does not protect assets. And clients would invariably say, well, why did my estate planning lawyer give me a living trust that is revocable if it's not going to protect my assets from claims of creditors? Why didn't he give me an irrevocable trust? And, that can be argued so many different ways. Maybe it's not the job of an estate planning lawyer to protect assets. And clients can say, well, you should have thought of that. You should have at least advised me that there is no protection. I understood this trust will protect me from all ill fortunes that may befall me, like probate, taxation, creditor claims, and gout. And it's going to maybe a tough fight for the lawyer to say, well, it was not my job, right? More and more obligations or duties are imposed on lawyers every day. And I think as the time passes, there will be an expectation that estate planning lawyers, at least, will have to advise clients to some extent with respect to asset protection, because usually it is such an easy adjustment to the estate plan to integrate asset protection planning into it. And such a huge service you're doing for the client. So in addition to trusts, we also use legal entities often in both estate planning and in asset protection. So in estate planning, we will use entities to accomplish a valuation discount, the so-called family limited partnership structures. The same structures can be used to protect assets from claims of creditors. So for valuation discounts in estate planning, we commonly use limited liability companies and limited partnerships. In asset protection, we similarly use those same types of entities to insulate assets from creditor claims. Because once you have assets inside of a limited partnership, or once you have assets inside of an LLC, those assets are not reachable by a creditor's claim. Because now you do not own those assets. The legal entity owns those assets, and the interest that you acquired in that legal entity is not reachable by your creditors. Creditors are not able to attach an interest in a limited partnership or an LLC. There's just no such remedy. So limited partnerships and LLCs, very simple, very straightforward, very inexpensive entities. If done in advance, right, maybe done as part of the overall estate plan, can be a very good asset protection tool should something bad happen in the future. And then finally, since we're running short on time, kind of on the more sophisticated side of integrated estate planning, and perhaps because we do so much international work in our office, we do often look at overseas structures. And these are sometimes overseas tax-oriented structures, like for our clients who are looking to minimize their estate taxes, either their US or worldwide estate or inheritance taxes. Sometimes they're income tax driven, but often these suggest, again, asset protection structures. Many of our clients will have assets around the world. So then certainly it makes sense to set up an irrevocable trust overseas to hold their non-US assets. But even for our clients who are US only, as far as their business operations, as far as their family, as far as their wealth holdings, often it does make sense to set up an overseas trust if the client can use that extra layer of protection that an overseas trust will afford them. So I am, encouraging every listener here, when you are considering estate planning, whether you are a person looking to engage in estate planning for yourself and your family, or whether you are an attorney who assists clients with estate planning, seriously consider integrating asset protection planning into the estate plan. Often it is sort of a natural extension of the estate plan. Often it is the same structures and entities that you use, maybe just tweaked slightly to afford asset protection planning. And sometimes it may be standalone structures, but which will produce a great benefit for your clients and will make clients very grateful to you that you've sort of gone above and beyond the call of duty and looked after their interests. Again, if you do have any questions about anything that either Michelle Lerman or I covered today, we are always happy to answer your questions. Please feel free to reach out to us. If you need the CLE certificate for this presentation, or you did not get a copy of our handouts, our white papers, Again, please feel free to email us and request those. We always welcome your communications. And both Michelle and myself, we are practicing attorneys. We're always grateful for referrals and introductions. Um, our practices are fairly national for both of us. We do represent clients across the United States, and in my case, really around the world. Again, I'm Jacob Stein, and on behalf of myself and on behalf of Michelle Lerman, thank you so much for listening to this presentation on estate planning and asset protection. Have a great day, everyone.